those show the changes from the existing ordinance that's in the book, and then the darker red in italics shows the changes from the last draft that you all saw. And just so really quickly, the first change is on page 1 of the red line draft 816-2.204, and it just all that did was just clarify a little bit kind of what it is that people get through this ordinance. So you don't necessarily have the right to a view, but you do have the right to go and try to get the view that existed when you purchased your property back. And that's consistent with the Tiburon ordinance, which is one of the ordinance we've talked about and which the Court of Appeal has said is a valid ordinance. The second change is on page 3, and that does include a change to the definition of view, and view also now includes, it means a range of sight from an exterior deck. But I know that was something that we had talked about but hadn't really decided one way or the other. And then the third change is kind of the same change that was on page 1. It's on page 4. It just says what right a claimant has, and that's the right to seek restoration of views or sunlight that exist out on the claimant's property, either when the claimant acquired the property, that's when the claimant acquired the property and the views and sunlight have been unreasonably obstructed by the growth of trees on someone else's property. So those are the changes from the last draft we've seen, and that's kind of where we're at.
Sorry, Tom, the under 816-2.40 rights, you're saying that's new, or that was in
it's an additional sentence. It's not really new, but it's just more clear as to what the right is that a claimant has.
Okay, so that's new though, since we saw the last draft.
Yeah, it's new, but not new.
Okay.
But yeah, the words are new, but the concept is not.
Right, got it.
Just on that same paragraph, if I could ask the question, so does living on a property mean acquiring it? Like there was some 20+ year difference between when I started living on my property and when my name was on the deed. And you're interested in when the name was on the deed, or that would be?
Well, so, without giving you legal advice, so what happened 20 years before you acquired?
Yeah, my parents bought the property and I was a child living on the property. And then I acquired the property some 22 years later.
Well,
acquired in the sense my name was then on the deed.
It's probably when you acquired it, but on the other hand, that would be something, if it goes to arbitration, that each side could present evidence about, and then an arbitrator could make that final decision.
Or a court.
Or a court, yeah.
Yeah. Okay. Thank you.
Mm-hmm. So kind of that's a summary of the changes. Robert, I don't know what else you wanted to talk about before Supervisor Joya gets on.
What are next steps if you all have time and don't have other issues?
Well, I think Supervisor Joya was thinking the next step would be to take it to the MAC one more time, because they had questions about kind of, well, what rights do the claimant have, and so that's why we added the clarifying language, and that was kind of mostly their focus. They did have questions too about the costs, and I know that somebody sent an email to Joy's office about that, and so if maybe you could just, for the group, ask your question.
Yeah, so this is a question that sort of came up after something that I experienced recently, and I hadn't really thought about this and how the section on costs is written, and there were no changes from the original draft, so, ordinance, right? So it's exactly how it's been for, the last 50 years or whatever it's been.
Right,
But in thinking about it, it started not making sense anymore because this was written at a time when there was a change in the law. And so there had to be sort of like a date set, where, okay, before, like, no one knew that this tree ordinance was going to go into effect. So it's not the property owner's responsibility that their tree is blocking somebody's view. But going forward,
right,
the property owner who puts the tree in knows this ordinance is on the books and needs to be cognizant of that. So what I started questioning, well, there are two things. One is what happened in my case is my neighbor planted some very fast growing trees probably in the last 6 years. And all of a sudden now we're starting to see that they're going to start impacting our views. And he knew, but before, he's moved here more recently. So the ordinance was already on the books.
right,
And so why would I be responsible for having to pay to trim his trees when he should not have planted such tall trees, knowing that they could impact many of the neighbors' views? And so that's one thing. And then the other piece is just, I know you have to kind of find a date and time, but it'll be just hard for anybody because now that there's been, many changes in property ownership, how anybody would know whether a tree was planted on March 1st of 1984, or if that tree had been planted in January of 1984, it would be very difficult to know. So it's just a problem with, I don't know that we'll ever resolve that, but I was just thinking if there's a way to restate that or rethink that cost question, because those are two things that are, I think, problems.
yeah, well, Curtis and I talked about it for a little bit, and there's a couple of thoughts. Well, first of all, maybe it makes sense not to have that date in there. But the other thing is, if we're gonna make the property owner always pay 100%, then they're not gonna really ever have any incentive or very little incentive to go to arbitration. And that the beginning of that section actually says that if the parties agree to the cost allocation at the beginning, that's what applies instead of the 50%.
Yeah, so maybe take out the 50%. That may end up being how most get decided, but it's still a problem, because somebody could just put their foot down and be very, abstinent about
Yeah,
doing anything.
I joined late.
Yeah.
yeah, John, we
but
went
I-
over.
Were you reviewing the changes in dark red?
We did that already, yeah.
And everybody understands the changes that were made from the last version, which added the view off the deck, correct?
Right, that, and then we just clarified a little bit more what a claimant's right is, which really wasn't a change, it was more of a clarification. So everybody seemed to be okay with that.
The major change was that the area off the view off of a deck is protected as well.
Right.
That's
Right.
there. And then there was some additional language about we made clear this 816-2.44 that a claimant has the right to seek restoration of views or sunlight that existed on the claimant's property when the claimant acquired the property where the views or sunlight have been unreasonably obstructed, right?
Right. Yeah, so we talked about that and everybody seemed to be okay with that. And then we also pointed out that language is kind of also reflected in the purpose and intent at the beginning.
Correct. So
Yeah.
now you're talking more about the date issue where.
Well, as it relates to the costs and how costs are allocated.
Pull up that section.
Yeah. So
Yeah.
I think you still have to keep the piece in that if, before the ordinance came into effect, so that was 1984, I guess,
Mhm.
that then it would be totally on the claimant because the tree was already there.
Right.
I guess I feel like that part makes sense, but otherwise.
Can you
it's-
pull up the section that has the payment?
Yeah, that's the last page, Robert.
Yeah, it's the very end of the ordinance. There.
Cost, a little
Yeah.
scroll up here a little more, right?
Yep.
The cost hold on, the cost of arbitration and all mandated restorative actions and replacement planning shall be apportioned between the claimant and the tree owner as mutually agreed to, or in the absence of an agreement as follows. The claimant and the tree owner shall each pay 50% of all cost in those cases involving any tree planted after March 1, 2084, and then all case ownership 100%.
Yeah, but I get,
But-
yeah, there
So
are,
I want to make sure, so if the tree was planted after March 1, and the reason of, isn't this, doesn't it go back to the date of when somebody moved in?
No,
Well,
yeah, okay.
yeah, so this was in the original ordinance, and so that date comes from actually when the original ordinance was first adopted way back in the 80s. So that's why that's there, and this language hadn't changed really too much from the original ordinance. But I did, before we kind of delve into that too much, there are actually two other sections that talk about costs. So maybe we could go to those as well. One is section 816-2.606G, which talks about how costs are allocated.
What section?
So it's on it's on page 8 of this. So if you go up 2 pages. It starts, it's kind of in the middle, at G. Yeah, so that the arbitration board allocates costs if it does go to the arbitration board. So that's one cost section.
Well, it just says the tree arbitration board will issue a written decision. The decision will include the tree arbitration board's findings, required restorative actions, and an allocation of all cost.
Mhm,
Well, that would be fair, right? You're leaving it up to the arbitrator.
right.
I mean,
Yeah, but-
everybody agree? I mean, I don't think you can pre-decide the facts prior to an arbitrator.
Right. The problem is that, like, hopefully most people won't go to arbitration, but if you don't have something in there that is somewhat specified, you could have a problem where no one will do it, you know, I mean, everything will end up going to arbitration otherwise, you know, like, people need some guidelines, like what they're obligated to do. On the other hand, if you don't, then everything's gonna go.
What would you pre-decide though, Gail? I'm not clear. I understand what you would pre-decide.
Well, okay, so right now, like, you know, I have a situation like on my block, so there's a tree behind me that blocks my neighbor's view, but it's been there for, you know, 80 years. So, and it was blocking her view, you know, way back when, so it's her obligation to pay for the restoration of her view under the ordinance now. It's done. We don't have to go to arbitration over it because it's clear in the ordinance.
What,
And there's
wait, but I'm not following.
Well, what I'm saying is when it's clear in the guidelines of what the obligation of each party is, that helps, because then you don't have to go to arbitration. The arbitration tends to happen when people refuse to take any action. Like, I wouldn't want to have people like,
No action can be taken on a tree before 1984 unless both parties agree to it. Am I not right? At 1984, all trees
Right.
existing had their own rights. And
yeah, the trees have rights.
Those rights are
before.
still, yes, those rights are still in
Right.
order.
So the tree would have to have been planted after 84.
Right. So that's the only ones that I was like really concerned about was, so.
Although if they could have been planted before 84. But if someone moved in 5 years ago and the tree didn't block your view and now it does, don't they have a right?
They do after.
Yeah, they have a
19
right. It's just about the cost
Yeah.
allocation.
Yeah.
So that's all we're saying is that, like, if you bought a house, again, this goes back to the whole thing. You bought a house and you didn't have the view, you don't have a right necessarily to the view. You can ask, you can say, I'll pay for 100% of the trimming and you'll get that view. You know, it's not a restoration of the view, it's actually a new view. Right?
Right.
So you can do that, but it's very clear in the ordinance, if that tree has been there already for 60 years or whatever, then you're obligated to pay the cost of that tree work. Like, we're just talking about the cost. We're assuming both parties are mutually agreeing to trim the tree. It's just a question of the allocation of the costs and how that
well,
gets.
don't they get to decide that between themselves?
No, right now the ordinance is very clear that if that tree was there before 1984, it's the claimant, it's the person wanting the view that has to pay for it.
But
No, as mutually agreed to. That's in the first line of 816-2. So they can mutually agree to whatever they want.
Well, of
But
course.
if there isn't an agreement,
Right,
then it's on the claimant if the
right.
There's no.
tree.
yeah, what's the section on
there's
that
no
again? Right.
obligation Of an owner of a tree, there's no obligation to maintain the view. But John, I think you were right in saying that if a view was established at some time during a property owner's occupancy of their property, that it would reestablish that view line, and I guess that's what we're trying to discuss, right?
Right, well, yeah, just because a tree was planted before 84 doesn't mean it has a right to grow as big as it could grow without being limited, right, Tom? I mean, isn't it true that whenever the tree was planted,
Right.
when you move in, when you move in, you have a right to the view that existed when you move in. Is that correct?
That's right. Well,
Right.
you have a right to
So-
seek that view. Yeah.
Yes, right. And
Yeah.
so let's say you move in 2000 in a tree that was planted in 1970. You move there in 2000, you have a view. That tree's now grown and you don't have a view. You can go back to get protection to the view you had when you moved in.
Well, that would be a radical, yeah, you can arbitrate it. I mean, but under the ordinance, you can always go through this process and argue that you have a right to that view and that if you're willing to pay for it. So the question was, in the past, it was always like, if there was no mutual agreement about paying for it, that the person who wanted the view would have to pay for it.
That's
Right.
Or the
True.
arbitrator decides that through the arbitration.
But what I'm trying to say, John, is that we're trying to avoid people even having to go through arbitration. We want an ordinance that's very clear of what people's obligations are, so they can just follow the ordinance. Arbitration is like kind of we hope that's a limited number of people.
Well, that would be let's go initial reconciliation, which is 816-2.602. Let's deal with it there. 8-6.2.602 initial
Or
reconciliation.
can you scroll to it, because I'm not sure where you are.
Yeah. 816-2.602, which says, if a claimant who believes in good faith to grow one or more trees diminishes the beneficial use, the claimant shall notify the tree owner in writing of those concerns. When a claimant notifies the claimant should also attempt to discuss those concerns in person with the tree owner, and if possible, to enable the claimant and the tree owner to attempt to reach a mutually agreeable solution to the alleged view obstruction in accordance with the provisions of this chapter. That's leaving it to the two parties to figure it out.
Right.
Why should we put in there who's to pay? Because there's so many permutations of it. And this is saying, try to reconcile it. You all get to figure it out.
Well, I'll just say that I know for sure that if we take out what the current law is around the claimant getting 100%, like there'll be 2 arbitrations going before your board, because my neighbor up a hill from me will say I should pay for restoration of her view. And then I'll say to my neighbor in front of me that they should pay for the restoration of my view. I don't really want to have to go
But
through
there's
that.
nothing in the ordinance that says what the parties should agree to. Right, Tom? I mean, they can do whatever they want.
No, that's not true. That's what we're going back. In the last section on costs, it says that's like the ordinance bottom line is either it's 100% to the claimant if the tree's older
let
than
me-
been planted
let
before
me look at-
1984.
What's that section? The cost of arbitration and all mandated restorative actions and replacement planning shall be apportioned between the claimant and the tree owner as mutually agreed, or in the absence of an agreement as follows. That's only the cost if it goes to arbitration. It's not that, Tom, correct me if I'm wrong, 816-2.804.
No,
2.804, let's
Yeah.
scroll to that.
Uh-huh.
It's toward the very end. Yeah, this provision of cost does not relate, right, to reconciliation or mediation.
Right, so you're right, reconciliation, mediation, those are both voluntary, so maybe in each of those sections, we add a sentence say, the parties, something like the parties will also, attempt to work out. an
Right.
agreement on
I don't
cost.
think we want any presumptions here. I mean, what
Yeah.
this cost provision only applies to mediation, to the cost of arbitration and the mandated restorative action under the arbitration. And so under initial reconciliation and under voluntary mediation, it says the claimant may propose mediation by serving on the tree owner a written request. Acceptance is voluntary. If mediation accepted, the parties shall mutually agree upon a mediator. And then it says, yeah, so maybe under both sections, it can say, like under the voluntary mediation, the mediator shall recommend an apportionment of cost. And under the initial reconciliation, the parties shall agree to an apportionment of cost. And so we make clear that this arbitration cost issue only applies to arbitration. It does not apply to mediation or reconciliation.
Well, okay, let me just say that, and maybe this is my misinterpretation of the ordinance for the last 25 years, but I've always used that formula for, instructing people that that's the way the county sort of perceived the allocation of costs, which worked. I mean, I'm just saying, like, basically then.
This is the new provision. I don't think that this paragraph was not in the original. What was in the original ordinance?
It was in a
It
different
is.
place.
The reconciliation was there, but not voluntary mediation. That's
Right.
new.
Right.
No,
But
no,
I'm
I'm
trying
saying
to
that-
see, where was there a cost breakdown on initial reconciliation?
There wasn't.
Yeah,
Well, it was written as a separate section after procedure. So I
I
just
think-
say that people have been using this as a guideline in the past for how they would distribute costs among neighbors, and so, or between a claimant and property owner.
but I guess here's the deal. Initial reconciliation is that they have to work it out between themselves. Otherwise, it's not initial reconciliation. It's if they can't work it out, and that working it out means what do they need to do and who pays for it, right? And then under mediation, same thing. What do you need to do and who pays for it? So I don't see how you lay out a mandatory. I mean, if you can't say under initial reconciliation, oh, if you don't agree on the apportionment of cost, then this is what apportionment of cost are, then that takes away then that's not in reconciliation. I mean, it's like.
But
there's
it's also a good suggestion, though, that, when Gail is advising people or we're talking to our neighbors, we can point to this section of the ordinance and say, well, this is how, if we went to arbitration or court for that matter, this is the suggested apportionment of costs, and it's more of a suggestion for people who are mediating or just agreeing to something.
Well,
It's a guideline in that case.
But it is by virtue of saying, if you go to arbitration, here's what's going to happen, right? It basically says, the cost of arbitration, all mandated restorative actions shall be apportioned between the claimant and the tree owner as mutually agree to, this is in arbitration, or in the, we want to be clear, this cost only applies to arbitration, or in the absence of an agreement as follows: the claimant and tree owner shall each pay 50% of all cost. Just looking here, an arbitrator under the arbitration section, there's also the tree advisory board, right? The fact finding, the tree arbitration board, here, like under the tree arbitration board will issue a written advisory decision. The decision will include the tree arbitration board's factual findings, and a recommended allocation of all cost. Right?
So that's ambivalent. So the two sections contradict each
No,
other.
no, they
somewhat.
don't. No, the tree, there's a tree there's fact finding and advisory decision by a tree arbitration board.
Oh,
So that applies if you don't if you can't reach an agreement in mediation. I mean, if you don't reach an agreement through reconciliation or mediation, and you don't go to binding, there's 4 things that can happen: initial reconciliation, mediation, binding arbitration, or if you do none of those, a fact-finding advisory decision of the tree arbitration board. And in the case of advisory decision of the tree arbitration board or mandatory arbitration, the arbitration board or the arbitrator can apportion the cost. That's what
Well,
the ordinance is saying.
I just say that I don't think that you should be putting additional rights into this ordinance that weren't there when the trees were planted. If the tree was, before the ordinance went into effect, there were already these huge trees in Kensington.
Right.
And I'll say, like, one of them blocks my view right now. So, I understand this, but if you start giving everybody the right to have every tree trimmed and have to, it's not that they don't have the right to ask for it, but it's who pays the cost of it. And it's very clear that this section that's been in there for since 1984 says the cost of arbitration and all mandated restorative actions. Well, okay, whether they're mandated or mutually agreed to, it would be, I just think that we need to keep that piece in. I just don't think we should be.
What did the original one say?
It says
almost the same thing.
It actually,
It's-
yeah, the only reason it's red is we made some grammatical changes, but that it didn't change from the last draft.
And it's actually more allowing than the other cities, Sausalito and Tiburon. Anyone who wishes to recover their view will pay 100% of the cost in restoring their own view. I know there's the issue in regards to when trees were planted, and certainly there was, should be some. And so I think ours is a little bit better in regards to a restorative view, especially with someone who's planted something that, I as a neighbor called out to my neighbor saying, please don't plant that species. Again, a recourse like this at that time would have been extremely handy. But again, other cities do require that 100% of all the costs of restoring views are the cost of the person recovering the view.
So let me understand, Tom, this under the cost, the A and B. The cost of arbitration, all mandated restorative actions and replacement planning shall be apportioned between the claimant and the tree owner as mutually agreed to, or in the absence of an agreement as followed. Well, if you have binding arbitration, when it says as mutually agreed to, isn't it the arbitrator that's making the decision?
Well, so I was thinking about that. Maybe.
Why do you have a mutually agreed to when it's gone to arbitration? In other words, I'm looking at this. If it goes to arbitration, it does say in the arbitration paragraph,
right.
it says the arbitration for a tree arbitration board. It says under G? Under G, the tree arbitration board will issue a written decision to the parties. The decision will include the tree arbitrator's board findings with respect to the standards required, restorative actions, and it will issue, and an allocation of all costs. So the tree arbitration board, which is the arbitration, right? Must make under G determines an allocation of cost. So if that's the case, then under this other section on cost, there's no mutually agreed to.
Right, so maybe
That paragraph is inconsistent. The cost of arbitration and all mandated restorative actions and replacement planning shall be apportioned between the claimant and the tree owner as mutually agreed to, or in absence of. There is no mutually agreed to because the arbitrator's making. Am I wrong?
Right.
So
No,
I was
they
gonna,
could agree to it in arbitration, and I
Well,
think the line that should be taken out is that the
Well, it's-
arbitrator
well,
is going to make the
if it's-
decision
the
when it's already laid out here in a better sort of way.
Yeah. So
Just-
Tom,
so, yeah,
Tom,
my suggestion was gonna be to take out the part about the agreement, say the cost of arbitration and all mandated restorative actions and replacement planning shall be apportioned by the arbitrator, or in the absence of a separate cost allocation by the arbitrator, apportioned as follows.
No, but I think what we need is something, so I think we need something in the ordinance that's really clear about what the intent is, so that people
Well-
don't have to go to arbitration. Because we don't want people to go to arbitration, like that's for the cases that have just been difficult. It's so much easier when you have an ordinance. that
They
this is
could
how
be
you
held
do it.
liable for costs. I think the fact that the person with the tree could be held liable for costs in arbitration, whether or not they agree to it or not, is enough to, I think, force people back to an original agreement, which is laid
Right.
out pretty clearly at the beginning.
Yeah.
yeah, I mean, here's what's gonna happen. If someone doesn't go to arbitration, it's gonna go to the tree arbitration board. And the tree arbitration board, it's gonna go to them for fact finding and advisory decision by a tree arbitration board. And that says under F, the tree arbitration board will issue a written advisory decision, which will include their factual findings and recommended restorative actions and recommended allocation of cost.
Well, I think that really changes the whole, game plan that's been in existence for, all these years. I mean, I know it'll cost me a lot of money.
To do what?
um,
To do what?
Because I would think that my little old lady above me who doesn't feel like she should pay for the tree restoration, even though the tree blocked her view before I bought the house, but now complains about it and wants it. And I've always said she can absolutely have it trimmed, but she doesn't want to pay for it. She thinks I should pay for it. All
But
of it.
isn't that what the tree arbitration board is supposed to say? Did this view exist? I mean, what you're trying to say, here's what we're trying to say, and figure out how to say, is that if somebody's view was blocked when they moved in, and they're seeking to reestablish a view that they didn't have, then somewhere in here it can say that they should bear the cost of that, of trimming the tree. Isn't that we're saying, Tom, that if isn't there a standard we're trying to say that if someone, I mean, in a lot of cases, it's going to be unclear. It's not always going to be clear. That's
Well,
why.
yeah, we're never gonna have, I mean, it's gonna be very difficult. Most people won't have photos.
Right.
I mean, it's gonna be hard. And even a photo, you can't tell because they can be faked.
Yeah, nowadays with what you could do, I don't know how you have real accurate evidence to show what your view was.
I know, that's why it was kind of like, well, if the tree was existing before the ordinance ever went into effect, that's just kind of like
Yeah, but
on you.
so why are we Tom, what's the value of the date under the cost section? Why is that relevant?
At the beginning, I mean, I think that date just comes from, this ordinance was originally.
Yeah, I don't
adopted
think
in
that date is
1984.
relevant anymore. That date is not relevant. That date
Well-
was in the original ordinance. What's relevant is the standard of whether you had a view when you moved in.
Yes.
That's the standard. Whenever the tree
Yes.
was planted, right?
For, yeah, for being able to seek restoration, but for allocating costs, the date is relevant for how much the claimant and tree owner should pay. And I think the whole section on cost should stay there pretty much as it is to give a good guideline for allocating the costs. May I say quickly, there's two other problems. One, the cost of arbitration, which will be set by the arbitration board, that I imagine that's going to be a lot of money because the county has been charging a lot of money for things. So, and the other problem is the word all in A, the claimant and tree owner shall each pay 50% of all costs. And the all sort of implies there's more costs above what is in the preceding sentence. Does that make sense? So for me, having the word all under A puts in some ambivalence, like you could actually have more costs than the costs
Yeah.
already stated.
I guess I go back to the basic issue. I'm not sure what the purpose of 816 2.804A is, because the arbitrator is going to decide the cost. It says here, it does say it shall be apportioned as mutually agreed to or in the absence of an agreement as follows. Again, I don't understand, Tom, the purpose of that phrase, this provision, because the arbitrator is deciding this, not.
Right, so I think once.
I want to be clear to everybody. This
I
would-
understand your point, John. So what we need, but I think what I'm saying, and maybe some others, is that we need something in the ordinance to give like as a guideline to people so that, I mean, people can do whatever they want, but if we don't have something specified in here about what the rule is, then everything's going to go to mediation or arbitration.
Well, I mean,
And be a big fight.
And it's just,
and-
it's going to be costly for people. It's going to be very unpleasant. It just helps so much when it's like in the ordinance, it says like, this tree was here since X, whenever, before this ordinance came into play.
But that's not the
I'm
relevant. The
really
relevant
agreeing with
standard is
Gail.
not how long the tree has been there. The relevant standard is
Well,
whether,
it was in the old ordinance.
right, but now the relevant standard is, did you have a view the day you moved into your house? Right, Tom? Isn't that the standard?
that is, yeah, that's what we measure everything.
Yes,
for.
I think
Or-
in a way
or
this
it-
ordinance changes some things. What we're saying very clearly, like we're 40 years since this ordinance was passed in
I know.
84. What we're saying is that, I guess it's 40 years, yeah, is that you have a right to the view you had when you moved in, period, end of story.
I
Doesn't
get
matter,
that, but there is no way to prove it anymore.
right?
That's the problem.
Well, you have common sense and you have photographs,
No, that's what we're saying.
and you know how
Photographs are
fast certain
useless.
species of trees grows.
Yeah, I do think it's gonna be hard to prove this. I get it. And this is where I do think people are better off going through the first two steps, which is reconciliation or mediation. Because, and people are smart if they know how am I gonna prove this? I mean, so what do you do if it, so again, I don't understand the distinction between a tree planted before 84 and after 84, because I think that's a false date today, because you could have a little tree that was planted
Mhm.
before 84 or a really big tree after 84. So I mean, that
I
issue,
think, John, this is my guess of what the thinking was that this was going to be a new requirement. And so if you planted a redwood tree back in, say, 1970, and you had no idea that this ordinance was going to be on the books, then like who should be responsible for that cost? I mean, I think it was just out of like, kind of like, otherwise I think people would have been opposed perhaps to the ordinance because they would have realized, oh, now I'm gonna have to take out this tree or do something to it. So
Yeah, I had
I
a
think that's
question for
probably
the-
why.
I had a question for the group. Does everybody think that it's kind of fair? I mean, every case is gonna be different, but is it relatively fair to have the cost kind of split?
Which cost?
All costs, like the cost of if you go to arbitration, those costs and the cost of trimming your tree. Or whatever other actions you have to take. Is it kind of, is the consensus of the groups think that that's fair, or is it more that?
Well,
somebody-
let me divide up. the
I
cost
do.
Let me divide the costs into two. My feeling may be different. I think it is fair to have let's take aside restorative cost.
Mhm,
I think it is fair to have the process cost split.
mhm.
If people can't reach an agreement, the processing cost of going through the process should be split. If you think about it, when you go to court, you each pay your court fees. The only time there are certain provisions of the law, you can go in and recover your attorney fees, right? But I think, basically in most litigation, everybody bears their cost. Right, Tom?
Yeah,
I think everybody, so I think the cost of the process, whether it's tree arbitration board, arbitration, well, obviously in arbitration, that cost should be split. I absolutely feel that. That's how you get people to go to arbitration. You split the cost. You go to court, you split the cost. Obviously, in mediation, it's going to be, they're going to figure this out themselves. In reconciliation, they're going to figure it out themselves. On an advisory board decision, obviously the claimant, whoever's filing for the opinion, the advisory decision is paying that cost. The question is, does the court then order to split those costs? So let's take the first case of arbitration. Can we all agree that the cost of arbitration should be split?
Yes.
But I would say that if a tree existed and some.
No.
Get to that later.
No, if I have to go to court on this, I'm going to pay to do something. I have to pay my own cost. Why should arbitration be any
Court
different?
costs, yes, but the preservation of your view.
No, right. No, I'm not talking about
Okay,
the
sorry, I'm sorry.
cost of restorative actions. I'm talking about the process cost of arbitration. I don't think there's anyone that's going to convince me not to split those costs. I think that's the right thing to do.
Well, it really depends, John, on what the regulations are. So again, this goes back to somebody wanting something that
Gail, I'm not talking about the cost to cut the tree. I'm talking about the process cost of going to arbitration. It's like when you go to court, you pay your own cost.
No, I understand. But okay, let me just sort of clarify this in my head of how I'm thinking about it. Is that if I knew that the rule was this, you have to pay 100% of the cost for the tree that had already been blocking your view all along, but you want to have a better view now. I shouldn't have to pay for that.
I'm not saying you are. Let me say, well, that gets to the cost of cutting the tree. That's a bigger cost. I'm saying the process, the cost of paying the county and whoever to go through the process to make the decision is borne equally. Then now we'll get to the second issue in a second. Who bears the more expensive cost of trimming or cutting the tree? That I agree with you. But on the process, this is no different than going to court.
Well, I see that
And it's
point.
mutually agreed upon to go to binding
Right. If you
arbitration.
both go in
don't enter
arbitration,
into it unless you both agree to
you're
go to
splitting
it.
the cost of the cost of the process of arbitration, not the solution. Like if you have to go to court on something to force somebody to do something,
Right, I get that.
So let me just say, can we agree? Because Tom, that's something that should be in here, is the cost of arbitration of the process are split equally.
Yeah, I think that makes complete sense, and we can add that.
Okay, now getting Gail to your point, which is the point of establishing, I mean, establishing a value that, right, if somebody is trying to, is reestablish a right of view right that did not exist, then yes, they should pay for the cost of the restorative action.
Right. So I don't, yeah, I mean, if you feel like a date isn't gonna help that.
No, a date's
that's
not gonna
one
help.
thing.
It's
But the problem is it's gonna be very difficult. You know, I mean, I just feel like this is gonna just drag a lot more people into these arbitration.
I don't
I
think it's any
have
different than putting a date, because one, it's gonna also be hard to prove a date, although
Okay.
you could. I think that's gonna be hard to prove. I think the bottom line is that there's a problem here that how of their, so I don't know what happens if there is no evidence. This is what's gonna happen, right?
Mhm.
If you're in arbitration and there's no evidence of whether to know whether somebody had a view or not. Yeah, you know, there's lots of ways. If it's unclear, what is an arbitrator going to decide? We're not deciding an outcome here. The arbitrator is going to may just say, split the cost. If there's no
Right.
evidence, that's what the arbitrator may say.
I know, but this is a real problem because it's gonna start costing people who never
But
had
that's
to
a
pay for
problem
that.
today going to court. Same
Well,
thing.
most people are not going to court. But what's really helped
Right.
is having, okay, I'll just say advising people in this community about what the requirements are has helped people just move it forward. And they may have decided to share the costs in a different way or not, I don't know, but it was helpful to
Right.
have that in the ordinance.
So let me go, there's two comments, Lemwalt, I'm sorry, who's that? Lemwolt?
Lynn, your hand is raised. Did you have a question?
Yeah, sorry. So yes, I have a question. What happens when trees either came up as volunteers or were planted in the public pathways? Nobody owns them. Where does one go to get permission?
Oh, this is Lynn Walter. Hi, Lynn.
Yes.
Okay,
Hi,
got
hi,
it.
John. How are you?
Tom, this applies only to private trees on
Private
private
property.
property.
Yeah, no, if it's like in the county right of way, you can call the county and the county may or may not do something, but yeah.
And
This is just trees on private property.
No, it's property that nobody owns. That's why it's problematic. The only thing that
What property are
exists,
you talking about? Did you say
the
that?
paths, the
Oh,
paths, the
yeah, yeah.
public
Well,
paths.
that's a whole different thing.
Yeah, that's, if it's the
Jersey
public right, if it's the
are
public
good
right
things.
away, if it's the paths, it's the wild, wild west.
Yeah,
There's no trees in those paths anyway.
that's a separate working group that's trying to solve that problem.
Yeah,
Oh, okay. I did not know.
But it's the
So-
working group on the paths, right? Right, we have a working group on paths dealing with working on the paths separately. But yeah, I think here, yeah, I don't think this ordinance addresses that because you don't know who the property owner is. Now, here's an
Right.
interesting question. Let's say it's the path and it's in the control of one property owner, sort of, right, next to them. Who knows? They may just go out and trim it themselves.
So do the neighbors who are losing their views have a right to go down and,
Trim it?
take down the tree with an
That's
arborist?
yeah.
I don't know. Well, I don't think, we don't know the answer to that. And let me just say, I think, since it's not on anybody's property, unless some neighboring there could be, here's what could happen. A neighboring property owner may like the tree and the other property downhill, uphill doesn't because it blocks their view. So that, let's say the person whose view is blocked goes down and trims it. And the neighbor who also doesn't own the tree but lives next to it is going to complain they're harmed. That's a civil action between them. We can't get into that and let them go to court on that. I don't think we can resolve that. I mean, it's sort of, if people want to take the law into their own hands, that's at their risk either way. This ordinance
So-
would deal with it. It can't.
So the people who planted the trees or have allowed them to grow above the roof line, contrary to where they'd been maintained historically. And so now property owners are losing their views. So do those property owners losing their views have no rights?
Well, they have nobody to enforce it. I don't know, Tom, there's no one to enforce it against.
Yeah, I mean, somebody always owns property. It's just in the past, you don't know who that person is. So, yeah, it's
There
just
is-
problematic. And anytime you kind of resort to self-help, that's a little problematic too. So,
Yeah, I don't, this ordinance doesn't legally address it, Lynn, because
Right,
it applies,
Is there
the
an occurrence
path
of
is
it?
private property, you just don't know whose it is. Right? They're long gone or unavailable. And
Okay.
so I do think it becomes, I mean, we can't address, I hear you what you're saying, but it doesn't, until we resolve the issue of ownership of the paths, it's legal limbo.
so what do the impacted property owners do without the tree view ordinance to rely upon?
Well, the difference is the tree view ordinance, you don't have two parties. There's not two parties because you don't have you can't identify the owner of the property where the tree is located.
Right,
So I guess if they could find a tree trimmer who's willing to touch it without having the property owner approve of it, they could trim
If
it.
there's no proper, here's what will happen in practical matter. If someone decides to go down and trim the tree, the only person that's going to complain about trimming the tree is potentially somebody who lives on an adjacent we need to leave. Shira wanted to say something before she leaves. Can we have Shira just ask her question quickly? Because you have to leave in like 1 minute. Then we'll come back, Lynn, to your question.
I'm sorry that time doesn't allow. I literally have to be somewhere in 1 minute. So thank you very much.
What's the question? And we could try to get answered to you.
I pretty much put my comments in the chat. And I understand that a lot of people have a lot of input. It's just I'm wary of changing the rules mid-course to a very large extent. I think little tweaks are cool, but to totally upend things, I think would be inviting all kinds of craziness. It's already such an emotionally charged subject.
When you
And
say the owner should not have to bear the cost, all it's saying is the tree owner is going to just, if two parties go to arbitration, they split the cost of arbitration, just like under the existing ordinance. If they have to go to court, they split the cost. This is no different than what would happen if they went to court. They have to split the cost.
okay, I'm really sorry. I can't talk.
Okay.
about it.
All
I'm
right.
really sorry.
Okay.
I gotta go.
Okay,
Thanks.
sorry. Lynn?
yes,
So anyway, the answer, the ordinance doesn't deal with that. So if someone, I don't want to give legal advice, but if somebody goes off and whose view is blocked and cuts a tree on the path, then the only person that's going to complain is somebody who liked the tree, who may be a neighboring property owner. And I'm not sure what rights they have in court to enforce that.
okay, great. And then who serves on the tree arbitration board?
We haven't established, but we're thinking it could be the MAC.
Okay,
That's a
Thank
separate
you.
thing. Yeah,
okay, thank you very much.
Catherine.
Yes, I have several points and questions. One of the main questions is why is the Contra Costa administration getting into the judicial business by making this binding arbitration tree board in the first place? Because it seems to me as if the courts and the judges have a trained process and legal minds and objectivity to do a good job, and substituting an amateur board and taking over a judicial process just seems like the wrong direction to me, both for the county and for the citizens. I have dealt with some of these citizen boards, and they're not trained to make objective decisions or look at their own prejudices. And so
Oh,
they
right.
end up not being fair.
So my response to that is that I think the community seems to want a process that is less expensive and less involved than a multi-year court battle, because that's what would happen. That is, one, more expensive, two, takes longer, and third, judges aren't experts in trees either. Their decision is based upon the evidence presented to them, which is exactly what would happen here. Between as this calls for, the judges aren't experts in trees. They're going to rely on the evidence presented by both sides, which could be an arborist and other evidence. The tree arbitration board is going to rely on the same thing, evidence presented to it. Although we could make an attempt to actually appoint members of the tree arbitration board who have some experience with trees, like an arborist. So actually, there's a chance for better expertise on an arbitration board if we specifically say we want to have an arborist or two on the tree arbitration board and have a little more expertise than a judge. So I think and some other cities have done this. It's not unlike a planning commission, right? They're not experts either. Some of them may be, most are not. Their things are brought to them. It'd be like a planning commission or KMAC making a recommendation on, on projects. So it's not unlike that. And some other cities like Sausalito, Tiburon, and others have established these kinds of boards. So that would be my answer.
Right. Well, maybe I'll just say for the record, I don't think they work very well. That there isn't really, it's really that you're more likely to get an objective ruling in court than you are from a citizen.
Well, if you
board made up of
establish, right,
citizens.
of
Even
course,
if they're supposed tree experts, they're also have their own ideas about trees.
Right.
I've met arborists who feel that all trees should be saved,
right.
and others who feel like just point me at a tree and I'll cut it down for you. So there's,
So I guess there's,
and they're not
right.
trained legally.
Yeah, well, I hear you. So you're saying that there could be a risk, and they're not saying there's not a risk that someone is biased, and that's true. Someone could be. I guess there's cost and benefits to both, and a court case will be much more expensive and ultimately take years to resolve. A tree arbitration board will be much less expensive and be resolved much quicker. So there's people will factor that into their decision making, and people will go not to binding arbitration. If they don't, they'll be, remember, the final the advisory decision will get reviewed by go to court if someone goes to court after an advisory decision.
If one of the parties seeks the advisory, then the advisory would happen. But it wouldn't happen unless one of the parties would seek it,
The
right?
advisory decision only happens if one party wants it. They pay for that process, but it's not enforceable until it goes to court.
And the arbitration is binding only if both parties are agreeing to that
Right,
process.
right.
No one's forced into that process.
Right. No one's forcing them to arbitration. They have to decide this. So
Thank you.
I want to, so I want to get
And I'll
back.
just say
Yeah.
that I really agree with Gail that having the costs laid out with the division is very, very useful to the community. Thank you.
So let me just say, I think I stand pretty firm on this. After 25 years being in government of this process, the parties should split the cost of the process.
Sure.
Look, if you go to court, you split the cost. I think, Tom, that's where we end up here. Is you
Yeah.
split the cost
And
of the
I agree
process.
with that
Yeah.
too.
And
But
so
It's
that-
just
Gail,
that it's-
getting back to Gail's point, the question, Tom, let's start with the principle.
Mhm.
I think there is agreement that if somebody who doesn't have a view right wants to, I mean, here's the point. Remember, the first two steps are what people agree to. We don't put in what they're supposed to pay. This is two adults, consenting adults, trying to figure it out among themselves. The question is, in the arbitration, do we put in a statement that somebody who wants to have a view reestablished, reestablished that they didn't have when they move in, should we state in the ordinance the principle that that person pays for the full cost of restoration of their view?
This ordinance doesn't deal in that situation because you haven't met the first principle, which is they didn't have that right when they moved in, or they didn't have that view when they moved in.
No,
So you never actually get to arbitration in that instance.
But is it arbitration is if two parties agree to arbitration, they're arguing over all of it, right? You could have somebody go to arbitration. If somebody goes to arbitration and the arbitrator determines, hey, you didn't have a view when you moved in. That's what the evidence showed. Do we then want to require the arbitrator to say, then you bear the cost of the removal or trimming of the tree?
I think we have to, and that, I mean,
Is that the standard we want to put in?
I mean,
Can
I think
I ask
that was the
for-
intent.
If the arbitrator finds that there was no view when that person moved in, there will not be any mandated restorative action.
Well, there's no
Because there-
mandated restorative action, right?
That's right. So the ordinance doesn't
At
deal
all.
with that.
I mean, we say that these are the things we want to protect. We're sort of giving a right that doesn't really exist in the law anyway. And we're saying we want people to have the views, but it's not mandated.
But then they can agree to pay for it. That gets to the first two steps, Gail, right? If let's say someone goes to arbitration and the arbitrator says, you didn't have a view. So we're not going to I want to get back to this issue, Catherine, you posed, but so if you go to arbitration and the arbitrator says you didn't have a view, right? Then there's no restorative action. And the only alternative the person has now is to work an agreement out with the other person. Right?
I'm sorry, say that again.
If you go to arbitration and the arbitrator says you did not have a view. Okay. So the result of their decision is they can't order you to trim the tree.
Right.
So the only way the person reestablishes their view is to go work out a separate agreement with the tree owner and say, I'm willing to pay for the cost to trim your tree.
Which is pretty much what the old ordinance said. I mean.
And it's the same, it's no different under this ordinance. Think about it. If you go to arbitration and you're denied restorative action, your only recourse is to agree.
I think the fear for me is that I have no idea what an arbitrator is going to make their judgment about. And because it's arbitration and it's not really a legal, I mean, it's.
Then maybe you wouldn't agree to arbitration.
Right.
If you don't agree to arbitration, then they would go to the voluntary tree arbitration. They'd pay the cost to go to the arbitration board and get an advisory opinion.
Right.
And then they would have to go to court.
Right.
And then that would force you into court.
Right.
Which is what you have now.
Right.
In a way, it's not different than now. I mean.
I will attest at how expensive that is.
Yes.
I think we're really encouraging people into easier solutions, and it's our responsibility to give them easier solutions that are written out. And
I'm not sure, Gail, your situation is different I mean, if you don't want to go to arbitration, then no one's forcing you to go.
No, but what I like having is an ordinance that just puts it out there. So there's two different pieces. There's some people who cannot get an agreement with their neighbors. It's not even a cost issue. It has some other issues like privacy or whatever, that they just don't want to cut their trees.
Right.
To me, that was really the purpose of this ordinance, was the people who just, like somebody says, I'm willing to pay for the tree to be trimmed, but my neighbor still won't let me trim it. That's what I thought this ordinance was trying to address. I always thought the cost issue was clear in the ordinance. So I get, and I still do, when I keep reading it, I still think that the county was basically telling the arbitrator, this is how you would decide it, if there's no other solution. And so we've always relied on that section in this community for how people would split the cost. And I know there's been a few cases where it just hasn't worked out and people have ended up in court. But to me, if you don't have something explicit in the ordinance, all these cases will end up in mediation, arbitration.
Mediation is okay, right? Because mediation is okay. That's not.
But I don't really want to have to go through mediation on my tree and the neighbor's tree. I mean, that's 2 trees already that I will be pushed into having to deal with, where right now we have clear guidelines on how to deal with it. And so
I'm not sure why it's clear. It has to go to court.
well, no, sure. If my neighbor was inclined to take me to court, but she's not willing to pay $500 for the tree to be trimmed. She's not going to go to court.
Then how does that change under this ordinance?
Well, so she might want to go to arbitration or something, and I don't want to.
Then
Suppose
you
the
say-
arbitrator says,
then
well,
you
you
say
should cut your
no.
tree for this lady.
Then you say no. If she wants to go to arbitration, you say no. You don't have to go to arbitration.
Right.
I'm trying to understand. So if she wants to go to arbitration, here's the point. If she can go to binding arbitration, but you need to agree.
Right.
She can go to a voluntary, an advisory opinion, which means nothing until she goes to court.
Right.
So I don't see how it's different. Do you see what I'm saying? In
Mhm.
your case, it may be,
Right.
it's not different. I mean,
I know it was just more straightforward before because like, as I say, I have the same issue. Like she wants me to cut my tree. I have a neighbor in front of me who I want him to cut his tree, but I pay for it because he won't. So like, I just don't want to get caught in a situation. It's so expensive now to cut these trees. I do not want to be paying for 2
Right.
trees to be cut.
well, no, you have no obligation to cut a tree. Gail, you have no obligation to cut a tree unless somebody, either one, you agree to binding arbitration, or 2, you don't, and they go to court. They still have to go to court. There's nothing, the only additional step that is here before court is that there's an advisory opinion, but they still have to go, they have to then pay for 2
Right.
things, which is an added cost. They have to pay for an advisory decision, 100% of that. Then they have to pay their court cost. So it's not changing. No, you're not being forced to do anything.
Right.
See what I'm saying? I don't think it forces you to do anything more than what you have to do now, but creates more opportunities to resolve disputes.
I know, but right now I can kind of rely on the ordinance to say, well, this is what the ordinance says, like if we went to arbitration, this is how it would be allocated. So at least I have some basis for like giving that person like the option of what they can do.
I mean, I suppose, there could, I don't know, Tom, is there a way to put a value, something that some general principle, which more applies to court, this applies maybe to a mediator. You can go to that says that the principle we're trying to achieve is that if you did not have a view and you want your view reestablished, that you pay for the restorative cost.
I mean, that's one way to approach it. The other way is like, well, each party should somehow share, and it's up to the arbitrator to determine how those costs should be split, because maybe somebody planted like a fast growing tree that wasn't really appropriate necessarily for their property. So yeah, there's different ways to approach it. And so maybe the solution is just going back to the arbitrator is going to allocate the costs of if there was a view that needs to be restored and there has to be mandated restorative actions and replacement plannings, then the arbitrator will just allocate those costs.
Right.
I mean, you could allocate them all one way or the other, or he could split,
Right.
he or she could split them 50-50.
But the only way they can order something in arbitration is if there was a right to a view.
Right. So
If there
there's
was no
to
right
the
to a
they
view,
they
the
never get to the
arbitrator,
cost.
right, if
no cost.
If
Yeah.
there's no right to a view, the arbitrator is not going to make an award that there was restorative action.
Yeah, so I mean, I think